Hello students and welcome to the lecture. So students, as you can see here that basically in this lecture, we are going to start with the judicial review and activism and the concept of public interest litigation, and it is going to be our part 1. Okay. Basically in this, all of these are the topics that we are going to discuss over here. Like starting with the definition of judicial review and the purpose of judicial review, in which we will discuss the definition and purpose part. Okay. Thereafter, the basic structure under the judicial review. We will discuss this also. In this, we will discuss the basic structure doctrine. Okay. Thereafter, we will see the procedure by law versus due process of law, in which we will discuss the process established by law and the due process of law. Then we will see the role of judiciary under the judicial review. In this, we will see the role of Indian judiciary, the suo motu causes, the public interest litigation. Thereafter, we will discuss the types of judicial review, like the review of legislative actions, administrative actions, and the judicial decisions. Then we will see the meaning and importance of judicial review. In this, we will discuss the meaning of judicial review and the importance of judicial review. Then we will have a discussion over the articles of judicial review, in which we will discuss Article 13, 32, 131, 132, 133, 134, 134A, 135, 136, 143, 226, 227, 245, 246, 251, 254, 372. Then we will discuss the problems of judicial review, like the limitation of the government functioning, overriding constitutional limits, separation of functions versus power, inconsistent adherence to the separation of powers, judicial precedents and standards, potential for personal bias, erosion of public confidence, scope of judicial review. Then we will discuss the introduction of judicial activism, in which we will have a discussion of introduction. Then we will discuss the definition of judicial activism in a proper sense, like progressive judicial power, expansion of individual rights, lawmaking by judges, personal views and decision making, evolving legal principles relating to the PIL also. At last, we will see the judicial review versus judicial activism, like the historical context, inherent nature of judicial review, expanded jurisdiction and PIL, and constitutional cases and judicial review. Before all of this, as usual, we have a disclaimer to be discussed here. Like the images used in a slide deck are for educational purposes only. We respect the intellectual rights of the original creators and the owners of these images. If you are the owner of any of the images used in this deck and have any concerns or issues, please contact us at sathi@iitk.ac.in and we will remove the images. So basically, if we talk about the first thing, that is the definition part, then we can say judicial review refers to the powers of court to examine the actions of the legislative, executive, and administrative branches of government to ensure they are in accordance with the Constitution. It is a mechanism to ensure that these actions do not violate the Constitution or exceeding any powers that have been granted by it. Purpose, if we talk about, like legitimizing the government action, judicial review ensures that the government actions are legally valid and within the powers that are granted by the Constitution. It validates or nullifies actions on their conformity to the constitutional norms. Protecting the Constitution act as a safeguard against any encroachment on the fundamental principles of the Constitution by the government or its branches. In this, if we talk about the basic structure doctrine, like the Indira Gandhi versus Raj Narayan case 1975, Supreme Court of India established that judicial review is a part of the basic structure of the Constitution. It means that any amendment to the Constitution that seeks alter or destroy the basic structure, even including the power of judicial review, that amendment will be declared as an unconstitutional. If we talk about the procedure by law versus the due process of law, first is the procedure established by law. This principle means that any law or action that has been taken by the government must follow the procedure that have been established by valid laws that have been enacted by the legislation. The focus is on the legality of the process, not to judge the fairness of the outcome or the result. In India, the constitution follows this principle, meaning that a law is considered valid if it is enacted through the proper legislative process, regardless the fairness any of it. Thereafter, we will discuss the due process of law. This principle goes beyond just procedural correctness. It means it requires that the laws must be not procedurally correct but also fair, just, and reasonable. Ensures that the rights of individual are protected and that laws do not lead to any arbitrary or unjust outcomes. Due process, if we talk about, is more commonly associated with constitutional frameworks like that of the United States, where it is a fundamental safeguard against unfair laws and actions also. Thereafter, if we talk about the role of judiciary under the judicial review. So first is the interpretational law. The judiciary interprets the constitution and its laws, ensures that their application aligns with the constitutional principles that must be inherited too. This involves determining whether legislative and executive actions are within the scope of the constitution or not. Thereafter, the observer, like judiciary, also monitors the function of various government branches, and that is done to ensure the compliance with the constitution norms and the principles by these government branches in order to get operated. Thereafter, the next concept is the suo motu cases. The suo motu, in a normal sense, it means on its own actions. It means the courts can take up the cases on their own initiative and not require a formal complaint or petition to be filed. This is often done in the cases of significant public interest where there is a clear violation of rights that needs immediate attention of the people. If we talk about the public interest litigation, so it is normally known as the PIL. It is a legal mechanism allowing the individuals or the groups to file a cases on behalf of the public or in the interest of the community, even if they are not directly affected by the issue. Aims to provide access to justice for disadvantaged or marginalized groups. Okay, the principle of locus standi, that is the right to bring a case, it has been relaxed to allow PILs to get filed. This means that individuals or organizations could approach the courts even they do not have a direct stake in the matter but are acting in public interest. Okay, if we talk about the review of legislative action, so basically this is the type of judicial review, like how many types of judicial review are there in the country. So if we talk about the review of legislative actions, so what is the purpose of this? The review of legislative actions ensures that the laws enacted by the legislature must comply with the provisions of the constitution. This type of judicial review checks whether a law is within the powers that have been granted to the legislature and whether it violates any fundamental rights or the constitutional principles that have been not granted. Thereafter, the process, the constitutional validity. Courts examine whether the legislative action aligns with the constitution or not. If a law conflicts with the constitutional provision, it may be declared unconstitutional and thus invalid by the court. If we talk about the examples of this, then like the Keshavnanda Bharati versus State of Kerala 1973, the Supreme Court held that while Parliament has the power to amend the constitution, but it could not alter the basic structure of the constitution. This case reinforced the principle that laws must respect the fundamental framework of the constitution and could not change. Minerva Mills versus Union of India 1980. Supreme Court invalidated amendments to the constitution that were found to violate the basic structure doctrine. Particularly, it is done to make the balance between the fundamental rights and the directive principles of the state policy. If we talk about the significance, this type of review generally maintains the supremacy of the constitution that ensures that the legislative powers are exercised within the constitutional limits. It helps preventing the legislative overreach and thus protects the fundamental rights. Second type of review is review of administrative actions. Purpose. This review assesses whether the administrative actions are lawful and within the powers that have been granted to the administrative agency, ensures that the administrative actions must comply with the constitutional norms and the legal standards. If we talk about process, first, compliance with law. Administrative actions must follow the established procedure and not exceed the authority granted to them. The courts review whether agencies acted within their legal bounds and followed the due process or not. Judicial remedies. If an administrative action is found to be illegal or improper, the court can issue order such as the mandamus to compel an action, prohibition to prevent an action, or certiorari to quash an action. If we talk about the case examples like A.K. Karaipak versus Union of India 1969, Supreme Court emphasized that the administrative actions must follow the principle of national justice, including providing an opportunity to the heard before taking action that affects the individual rights. R.V. Home Secretary versus Ex-Day Party. Although a UK case it was, but it illustrates how administrative decisions affecting the personal rights and these must comply with procedural fairness and the legality. Significance if we talk about. So this type of review ensures that the administrative agencies must operate within their statutory limits and adhere to the principles of fairness and the legality. Provides a check against any arbitrary or excessive administrative action. Then the review of judicial decision purpose. Judicial review of decisions made by court aims to correct or amend errors in judicial rulings. This type of review ensures that legal interpretations and decisions are consistent with the constitution that have been established the legal principle. Process, appeal and revision. High courts have the authority to review the decision made by the lower courts through the appeals or the revision. This process allows for correcting any errors that have been inconsistent in the judicial decision. Review of judicial decision. In some cases, court can review their own decisions for correction of errors and reconsidering the previous judgment. Usually done through the mechanisms like the review petition or the exercise of powers under Article 137 and 226 of the Indian Constitution. Case example, SR Bombay versus Union of India 1994. The Supreme Court reviewed its earlier decision on the imposition of president rule in the states, reinforcing the principle of federalism and the proper use of emergency power. MC Mehta versus Union of India 1987. Supreme Court revisited and expanded its earlier ruling to address environmental concern, illustrating how judicial review can evolve, adapt to new issues and all. Significance. This type of review ensures the integrity and consistency of the judicial ruling, provides mechanism for correcting errors and ensures that the judicial decisions must uphold the constitutional values and the principles. Thereafter, if we talk about the meaning and the importance of the judicial review. First is the meaning of judicial review. Judicial review is generally the authority of the judiciary to assess the constitutionality of the legislative enactment and the executive orders that have been issued by both the central and the state government. If such actions are found to be violated against the constitution, deemed ultra vires, the judiciary can declare them illegal, unconstitutional, and even invalid or null and void. Consequently, these actions cannot be enforced by the government further. Like there is a Justice Sayyid Shah Muhammad Qadri who has categorized judicial review into the three types. First is judicial review of the constitutional amendments, which basically seek the amendments to find out whether these are in adherence with the basic structure provisions or not. Thereafter, the review of legislations we have just seen, and the judicial review of administrative actions we have just seen. Thereafter, we know the Supreme Court of India has exercised its power of judicial review in several landmark cases, like the Golaknath case 1967, Bank Nationalization case 1970, Pirvi Percy's Abolition case 1971, Keshwada Bharti case 1973, and the Minerva Mill case 1980, and others. 2015, the Supreme Court declared both 99 Constitutional Amendment Act 2014 and the National Judicial Appointment Commission Act 2014 as unconstitutional, null and void, and cancel both the acts. If we talk about the importance of judicial review, first is upholding the supremacy of the Constitution. Judicial review ensures that the Constitution remains the supreme law of the land. For a statute to be valid, it must align with the constitutional requirements. The judiciary is responsible for determining the constitutionality of any enactment. Thereafter, maintaining the federal equilibrium. Judicial review helps preserve the balance between the central and the state government, ensuring that neither of them oversteps its constitutional bounds and exercise the power on each other. This balance is crucial for maintaining the stable federal structure. Thereafter, protecting the fundamental rights. Judicial review is essential for safeguarding the fundamental rights of citizens. The judiciary acts as a sentinel to ensure that these rights are not infringed upon by the legislative or executive actions. Constitutional supremacy. In India, it is the constitution that is supreme and the statutes must conform to constitutional requirements to be valid. Judiciary decide whether the enactment is constitutional or not. Role of judicial review. Our constitution provides for judicial review to ensure legislation complies with the constitutional provisions, particularly the fundamental rights. The court acts as a vigilant guardian of these rights and protect these rights from any violation. As long as the fundamental rights are the part of the constitution, the judicial review must ensure that these rights are not violated and implemented effectively. The constitution as a supreme law. The constitution is the supreme law of the land, and no branch of government, whether executive, legislative, or judiciary, is above it. Every branch derives authority from the constitution and must operate within these limits. The court is the ultimate interpreter of the constitution, determining the scope and the limits of each branch's power. Thereafter, judicial power and the fundamental rights. Judges have the crucial role of determining the validity of laws. Without this power, fundamental rights would be meaningless and constitution without effective remedies would become ineffective. Maintaining the constitutional balance. Supreme Court judges are tasked with upholding the constitution and ensuring that the balance of power between the legislature and the executive is maintained within constitutional limits. Purpose. The framers of the constitution wisely included provisions for judicial review so that they could maintain the federal balance, protect fundamental rights and freedoms, and adjust the constitution to meet the evolving needs. Judicial review is integral to the constitutional integration and the adaptation as well. If we talk about the articles of the judicial review, first is Article 30. Declares that any law which conflicts with or undermines the fundamental rights enshrined in the Constitution will be deemed invalid and enforceable. This provision ensures that laws must align with fundamental rights to be legally effective. Then Article 32 guarantees individuals the right to approach the Supreme Court so that they could seek the enforcement of the fundamental rights. This article generally authorizes the Supreme Court to issue the various form of directions, orders, or writs to enforce these rights effectively. Thereafter, the Article 131. This establishes the Supreme Court's original jurisdiction in resolving the disputes which involving the central government and the state governments or between the different states. This provision allows the court to decide the cases directly. Then, Article 132 provides the Supreme Court with appellate jurisdiction over the constitutional matters, allowing it to hear the appeals from the lower courts where constitutional issues are generally involved. Then comes the Article 133. This grants the Supreme Court appellate jurisdiction in civil cases, enabling it to review and adjudicate appeals on the civil matters and the matters that have been passed with the lower courts. Article 134. This provides Supreme Court with appellate jurisdiction in the criminal cases, allowing it to hear appeals related to the criminal matters from the lower courts. Then comes the Article 134A. This is generally for addressing the procedure to obtain a certificate for appeal to the Supreme Court from the High Court in certain matters. This facilitating the process of legal appeals. Then Article 135. Basically, this authorizes the Supreme Court to exercise the jurisdiction and powers that were vested in the federal court by the laws that have been enacted before the Constitution came into some extent, like the laws that were previously made before the independence or during the British era, but now even they are enforceable. This ensures the continuity in the judiciary authority. Okay. Then comes the Article 136. This empowers the Supreme Court to grant special leave to appeal from any court or tribunal, but having an exception on military courts and the court martial. This provision allows the Supreme Court to review the cases that were previously listed with the lower courts and now were listed with the tribunals. Then Article 143. This permits the President to seek the opinion of the Supreme Court on any question of law or fact, including the matters that are related to the laws enacted before the Constitution adoption. This helps in clarifying the legal uncertainties and ensuring the inconsistent legal interpretations. Then Article 226 grants the High Courts the authority to issue the directions, orders, or rates for enforcing the fundamental rights and for other purposes, thereby enabling them to uphold the constitutional provisions and protect the citizens' rights. Article 227 confers on the High Courts the power of superintendence over all courts and tribunals within their territorial jurisdiction, except the military courts or tribunals where they could not exercise the power. Ensures that the High Court can oversee and ensure the proper functioning of the lower courts. Okay. Thereafter, the Article 245 defines the territorial extent of laws that have been enacted by the both Parliament and the state legislature, and also specifying the geographic scope within which these laws could apply. Then Article 246, this outlines the distribution of legislative powers between the Parliament and the state legislature, specifying areas of jurisdiction under the three lists: Union list, state list, and the concurrent list. Thereafter, we have the Article 251 and the Article 254. So basically, this established that in cases of conflict where the central laws and the state laws are overlapping, in these cases, always the central law will prevail even over the state laws. This rendering the state law void, and this ensures the uniformity and supremacy of the central legislation in the matters of conflict. Okay, because the central law will be applicable even over the state laws, so that's why the central authority over the state could be ensured, and even the uniformity throughout the nation could be ensured because of these laws. Thereafter, if we talk about the Article 372. So this is generally to addresses the continuation of laws that were in force even before the Constitution was enacted. This provision generally allows the pre-Constitution laws to remain in effect unless they got altered or repealed by the new legislation. If we talk about the problems of judicial review, like so far we have talked about the process of judicial review, the provisions and all. Now, if we talk about the problems that are specific to the judicial review, then first is limitation on the government functioning. So if we talk about the explanation of this, we can say the judicial review can constrain the action of the government by invalidating the laws or executive decisions deemed as unconstitutional. This may limit the government ability to enact the policy and implement their agenda effectively, potentially slowing down or hindering the functioning of various government branches also. If we talk about overriding constitutional limits, explanation. When the judiciary exercises their power to strike down the laws, generally it can be perceived as exceeding its constitutional mandate, especially if it overturns the laws that were enacted through the established legislative processes. This can lead to the concerns about the judiciary encroaching upon the domain of legislature and altering the balance of power. Then, the separation of functions versus power. Explanation part. In India, the principle of separation of powers is practiced rather than strict separation of power. This means while the judiciary, legislature, and executives have their distinct roles, their powers could even overlap. Judicial reviews generally allows the judiciary to access and potentially nullifying the legislative and executive actions. This reflects this overlap can blur the lines of authority that have been set by the Constitution in respect of each other. Then, inconsistent adherence to the separation of powers. Explanation. The concept of separation of powers is not always strictly followed, leading to the instances where the judiciary intervenes in areas that were traditionally reserved for the legislature or the executive only. Okay, like we can say, although a system of checks and balances is in place to prevent any one branch from overpowering the others, the judiciary's ability to invalidate the laws can sometimes be seen as encroaching upon legislative or executive functions as well. Thereafter, the judicial precedents as standards. Explanation. The judicial decisions often set precedents that influence the future rulings. Once a court establishes a legal standard in a particular case, it becomes a reference point for subsequent cases also, which means like this reliance on the precedents can lead to a rigidity in the legal interpretations and may sometimes perpetuate outdated or controversial decisions as well. Thereafter, the potential for personal bias. Explanation. Always there is a risk that the judicial review may be influenced by the personal bias or the interests of judges rather than purely only on legal consideration. Okay, like we can say, if judges' decisions are swayed by the personal or selfish motives, it means it could undermine the fairness and the impartiality of the judicial process, potentially harming the public interest. Then, erosion of public confidence. Explanation. Like if the frequent judicial intervention would be there and then it will be a perceived overreach of the judiciary can erode the public confidence in the government's integrity, quality, and efficiency. If courts are seen as overly active or interfering in the legislative and the executive matters, it might lead to a lack of trust in the effectiveness and legitimacy of the government's action. Thereafter, scope of judicial review. In India, if we talk about the constitutional validity of the legislative enactment or executive order can be challenged in the Supreme Court or High Court on the following grounds. Like first is infringement of fundamental rights. The law or order violates the fundamental rights guaranteed under Part 3 of the Constitution. Thereafter, the lack of authority. The law or order was enacted or issued by an authority that did not have the competence to do so. Thereafter, repugnance of the constitutional provisions. The law or order conflicts with or it's inconsistent with the provisions of the Constitution. The scope of judicial review in India is more restricted compared to that in the United States, even though the American Constitution does not explicitly mention the judicial review. This difference stems from the constituting principles of due process of law in the US and the process established by law in India. In the US, the due process of law generally allows the Supreme Court to review laws not only on substantive ground but also on procedural grounds such as whether the law is reasonable or unjust. This broader scope enables the American Supreme Court to invalidate laws based on their fairness and procedural aspect. Conversely, in India, the Supreme Court focuses primarily on whether a law falls within the powers of authority that enacted it or not. Court does not assess the reasonability, sustainability, or policy implication. The extensive power of judicial review exercised by the American Supreme Court under the due process of law clause has led to some critics to be labeled as a third chamber of the legislature or as a super legislature that ultimately reflecting its significant influence on social policy. In India also, judicial supremacy is recognized, but it does not within the more constrained framework. Indian system blends from the American and the British model. It incorporates the American principle of judicial review, but also having the British policy of parliamentary supremacy. Thereafter, now we have the judicial activism to be discussed. Introduction part. The judicial activism refers to the proactive and assertive role that is played by the judiciary in safeguarding citizens' rights and advancing the justice within the society. Okay? It involves the judiciary taking an action stance to compel the legislature and executive branches to fulfill their constitutional responsibility. Judicial activity sometimes terms as judicial dynamism, contrasts with judicial restraint, which is characterized by the judiciary self-imposed limitation on intervention. Thereafter, if we talk about the definition of judicial activism, first is progressive judicial power. Judicial activism involves a judicial approach where judges deviate from strict adherence to the established precedents to embrace the progressive and innovative social policies. This approach often includes decisions that are aimed at social reform, which may sometimes encroach upon legislative and executive domains as well. Thereafter, the expansion of individual rights. The judicial activism characterized by the judiciary efforts to protect or extend the individual rights through decisions that diverge from established precedents or challenges that perceived constitutional or legislative intents. Thereafter, the law making by judges. In judicial activism, we can be described as judges actively interpreting the existing legislation to enhance their effectiveness for social improvement. This is distinct from the judicial permission, where judges interpret laws without seeking to expand their beneficial impact. Personal views in decision making. Judicial activism is a philosophy where judges incorporate their personal views on public policy and other factors into their decision making process. Evolving the legal principle. Judicial activism involves developing the new principles, concepts, and remedies to ensure justice, or to expand the scope of litigants' standing and enables the court to address the issues effectively to the society or specific groups. How it is relating to the public interest litigation or the PIL. Judicial activism closely associated with the PIL. The rise of PIL in India is largely a product of the Supreme Court's judicial activism. PIL represents one of the most prominent forms of judicial activism. It allows the judiciary to address broad societal issues and enhance the access to the justice for the people. If we talk about the historical context and the scope of judicial review versus judicial activism. Since the mid 20th century, a particular form of judicial review has been referred to as judicial activism, especially in the USA. In India, however, there has been confused between the judicial review and the judicial activism. Inherent nature of judicial review. Judicial activism is a subset of judicial review. Judicial review grants courts the power to uphold the constitution, to nullify laws and actions that conflict with it. Judicial activism therefore plays a crucial role in ensuring the branches of government fulfill their constitutional responsibility effectively or not. Evolution of the term. They both got evolved during the 20th century and both having the similar applications. Expanded jurisdiction and PIL. The expansion of locus standi through judicial interpretation, particularly in the public interest litigation, has generally broadened the scope of judicial review. The critics of this expanded roles often label it as a judicial activism, reflecting concerns about the increased influence of judiciary in addressing the public issues and ensuring justice. Thereafter, constitutional cases and the judicial review. Judicial activism in constitutional cases is often considered a form of judicial review. It is broadest judicial activism, involves the judicial intervention, results in invalidation of duly enacted legislation. This intervention underscores the judiciary role in overseeing and rectifying the legislative actions that may conflict with the constitutional principles. So here we have finished the topic. Now it's just a summary part. Like the definition we have seen, the purpose we have seen, key concept of the judicial review we have seen, like the basic structure, doctrine, process established by law, due process of law and all. Then the role of Indian judiciary in this we have seen, like the interpretational role, observer role. Then the types of judicial review we have seen, like in the legislative actions, administrative actions, judicial decisions. Thereafter, we have seen the meaning of this also. Types of review we have seen, like the constitutional amendments review, legislation action review, administrative action review. Thereafter, significant cases we have seen Kolaknath, bank nationalization, Kesavananda, Minerva, 99th Constitutional Amendment Act and all. Thereafter, importance of judicial review we have seen, like upholding the constitutional supremacy, maintaining federal equilibrium, protecting the fundamental rights. Constitutional articles which are related to the judicial review we have seen, like 13, Article 32, Article 131, 36, Article 226 and 227. Scopes and limitations we have seen, like limitation of government functioning, overriding the constitutional limits, principle of separation of powers, judicial precedents, personal bias, and the public confidence. Thereafter, we have seen the judicial review versus the judicial activism, in which we have seen the judicial activism and judicial review. Then we have seen the comparison with the US system, like Indian system and the US system. Then we have seen judicial review and PIL, and evolution and role, and etc. So students, basically in this lecture, we have finished the part 1. In next lecture, we will start the part 2. Till then, just revise the facts and figures that all we have discussed in this lecture. Be ready for the next lecture. With this note, let's end this lecture and thank you.